actually, whilst people are logging on, I might actually have some time to order some refreshments. This overseas remote working is quite thirsty work. Waiter, can I have a working on the beach cocktail, please? Yeah, working on the beach. Ingredients: it has few employment issues. It has a dash of tax and data security. Heavy on the immigration, please, and ice and lemon, if you could. Thank you. Oh, thanks. Fantastic. Right. Well, it is probably time for us to make a start. Welcome to our Employment and Immigration Breakfast Briefing. For those of you who don't know me, I am Tim Hayes. I'm a partner in the Employment and Immigration team. I typically help companies that are looking to get human resources into the UK. So this session is about the complete opposite of that scenario, because one of the queries that we're getting asked more and more is around the area of remote working, and not just any old remote working. Today we're talking exotic remote working, far away from the UK while still on a UK contract. Luckily for all of you, I've been doing some extensive practical research into this. I've come to the lovely beaches of Mauritius, as you can see behind me, to see exactly if a remote working arrangement can work. So far I've been here for 3 months and I think it's going pretty well. Between the scuba diving and cocktails, I have found time to prepare this webinar. Now, obviously the pandemic has turbocharged the whole remote working phenomenon. Workers who were once based in the office were suddenly required to work from home remotely in most cases. And some of those workers began to explore the possibility of doing so from abroad, or indeed had to, because they were stranded there in some cases. And after the pandemic, a large proportion of employers have retained at least an element of remote working where this is possible for their roles. And this has meant, in many cases, they've had to consider requests from staff to do that work remotely from another country. It can also be a great perk to offer to someone who the business is keen to retain or recruit, and you offer the opportunity for them to remote work from outside the UK as a benefit. This type of international flexibility sounds great in principle, but it throws up a whole host of legal questions included in my cocktail, which are often not straightforward to answer. And in many ways, the law hasn't really caught up with the post-COVID working world. Luckily for me, I have two of my colleagues here to assist on this webinar. I have Oliver Willis, a partner in our commercial team, who specializes in data protection issues. He specifically advises on transfers of data out of the UK and also on data sharing contracts. He'll be telling us all about what I can and can't send via email during my stay in Mauritius. As you will see, the budget stretched to, for this webinar, stretched to us sending him all the way to San Francisco to do some more field research, which I'm very pleased to say. Also with us is Marilyn McKeever from our individuals team. Unfortunately for Marilyn, the budget didn't extend to us sending her to an exotic location, but she's in our London office. She specializes in international and UK tax and estate planning, and she guides clients through the quite complex rules on domicile, deemed domicile, and residence. She actually, I should say, combines her practice with sitting as a judge of the first tier tax tribunal, which I think gives her an invaluable insight into the operation of the tax system, and she'll be taking us through some of the tax aspects of remote working later on. So Megan, if we could move on to the next slide, we can have a look at what the agenda is. We're going to start off with looking at employment issues. We're going to move into data security issues with Oliver. We're going to come back to Mauritius for a bit of immigration, and then we're going to hop over to London for some tax issues with Marilyn. And if we have time at the end, we'll have a look at a few case studies of employers who have implemented an international remote working policy. Feel free to put any queries into the Q&A box, which you should see at the bottom of your screen. I have to say there's quite a lot to get through. We may not have time to get through to the questions in the end. If we don't, we will wrap them up in the follow-up that we will do after the seminar has finished. And if you have any technical issues, put them in the chat box. My colleague Megan, who will be whizzing us through the slides, will be there if you have any technical issues. So without further ado, let's delve into the employment issues which are relevant to the issue of international remote working. What things should you consider if you receive a request to work remotely from outside the UK? Firstly, you've got to consider, is there a remote working policy? Is there a working abroad policy? If you don't have one, do you need to think about one? Now, you might think that having an international remote working policy is overkill, but there's probably at least scope to incorporate an international dimension into any existing policy on remote working or flexible working that you have. So having that consistent approach to how you deal with requests by staff to work remotely and internationally remotely, and being able to evidence that you've thought through that according to a written policy, that's going to be really helpful when you're defending any claim that staff have been untreated fairly or in a potentially discriminatory way. So if you don't have an international remote working policy, is there an ordinary flexible working policy that you can refer to instead? And even if there isn't actually a request to work outside the UK, it's ultimately a flexible working request, just as it would be if an individual wanted to work in, say, Swindon rather than Sweden. So you may want to ask the individual if they want to make a formal flexible working request, provided that they meet obviously the requirements to be eligible to make one. And that would mean then that you would be entitled to refuse the request on the basis of the grounds set out in the legislation. And that's things like additional cost. You know, if it's too costly for the remote working arrangement to succeed, then that can be a legitimate basis on which to refuse the request. Also, things like detrimental impact on the quality of work or on performance. They're perfectly legitimate grounds on which to refuse the request. The second thing you've got to ask is, how long is the arrangement for? There's obviously a very real difference between just doing a couple of days' work whilst you're overseas, maybe even interrupting a holiday, to then staying abroad for an extended period of weeks or months. Sometimes it's just, you know, a case of staff members perhaps taking a long holiday, maybe doing those few days' work during that period. Some lucky people might have homes abroad or family based overseas. So depending on the length of the intended overseas stay, you've got to consider, you know, is it practical for them to work remotely from abroad? And if the employee makes the request in the form of a formal flexible working application, these are the types of things that you're going to need to consider anyway. But even if they don't make it in that formal request, you may want to consider these things along the same lines. Can they realistically do their role from abroad? You know, there are many office roles that can be done remotely, but there are many reasons also why certain roles simply can't be performed remotely, and specifically not internationally remotely. Is there a time difference, for example, that's going to complicate communications with the team or with clients during the period of stay? Will the absence, the geographical absence, have a detrimental impact on the team or the quality of the work of the team or the individual? Does the individual need to attend meetings? And if they can't, you've got to think of why it's important, why it's crucial to their role that they attend those meetings in person. You know, their concerns about the country to which they're going. Obviously, Oliver's going to talk about data security, but actually, are there any physical health and safety issues? Obviously, employers owe that duty to ensure the health and safety of their employees. It's a non-delegable duty of care, and they've got to take reasonable steps to ensure the safety of employees at work. And that duty actually applies regardless of the fact that an employee is working abroad. So an employer is probably going to want to weigh up the risks of the employee working somewhere where there may be a risk to them personally, and also just in terms of their physical workspace. What kind of equipment will they need? You know, I'd say it's incumbent upon an employer really to scope out the physical working arrangements and ensure that any health and safety risks are mitigated. You might also, as an employer, want to ask why the request is being made. Are there any compassionate factors at play here which need to be borne in mind? You know, a request to by somebody who just wants to work overseas for a lifestyle choice, and that's very different from someone who has family who might be needing, you know, medical or emotional support for a period. You know, ultimately they may be wanting the same thing, but their circumstances are so different that to, you know, completely discount those compassionate circumstances may lead actually to a bit of unfairness and may justify a difference in treatment between those requests. Also, you've got to consider what kind of approval process is there. Does the policy set one out? You know, is it the line manager who has the final word, or is it someone else at a more senior level? So you need to consider, if that isn't stated in the policy, whether it's something that you need to you know, arrange into some kind of consistent approach so that you do have that consistent treatment between requests made by employees. So if we go on to the next slide, probably the most important thing that I will say on the employment side is to confirm the arrangement in writing. Kind of goes without saying to a certain extent. Ideally, you're going to get the employee to sign something acknowledging the terms of the arrangement. That could be a new contract, but I would say at least a side letter confirming those arrangements is going to be fairly key. And in those written terms, you're going to be making it clear that it's temporary, if it is temporary, and you'd be specifying an end date. Ideally, the employer is going to retain some degree of discretion to discontinue the arrangement, or at least to modify it significantly. Obviously, any discretion is going to have to be exercised reasonably. So if you do want to make significant changes to it, you're going to have to provide a certain amount of notice of those changes. But you'll at least want to build in a degree of flexibility if things don't go according to plan. You might want to think about a trial period. Is that appropriate? You know, manage expectations from the start, see how things go for a month or 2 or 3, and then arrange a meeting or a conversation at the end of that trial period to discuss whether it can continue. Make it clear as well in those written terms that the employee is working for the UK business only and not any overseas entity, which might lead to tax and other complications. Make it clear who's paying for what as well. Are there any immigration fees that need to be paid? And if so, is the employer paying for those? Is the employee paying for those? Who's going to have liability for things like additional tax? You know, income tax that might fall due, or social security contributions, and also are there any changes in benefits for the remote worker during the remote working period? In that regard, I would recommend that things like insurance coverage. You know, if there's any medical insurance, you probably want to check the terms of those policies to ensure that employees who go abroad are still going to be covered by them, and if not, are you liable to put something, you know, an alternative in place? You want to make it clear that actually you don't have that responsibility, and also make it clear in the written arrangements that the employee will be responsible for ensuring data security. Obviously, Oliver's going to talk about that in a moment, and also to get them to confirm that they will have suitable equipment and internet access in order for them to undertake their role from abroad. So moving on to the next slide, a very quick word on applicable law. Question often arises around what law applies to the employment whilst someone is working overseas. Is it the law of England and Wales, if that's the law that governs the contract, or is it local law? It's all well and good, obviously, in relation to employment rights governed by the contract, where it's stated that English law governs the contract, but there might be more favourable mandatory laws that the employee could benefit from that actually override the rights and obligations set out in the contract. The general position is that the law of the country in which the employee habitually carries out their work will apply. So you might have a circumstance actually where an employee working abroad might have the option to sort of forum shop, basically asserting that they they benefit from local employment rights, where those might be more advantageous. So, matters such as paid time off, minimum rates of pay, termination rights, that kind of thing. And you might have a situation where the local law actually entitles employees to better pension benefits or retirement or medical benefits. So you're going to want to determine actually whether you're going to be caught by these requirements. If someone is working on a remote working arrangement on a temporary basis, I mean, it depends on the length of the arrangement really, but the employment is likely to have a greater connection with English employment law. So they're likely to continue to benefit from UK statutory employment rights. Obviously, the longer that arrangement continues, the higher the likelihood that local employment rights might be invoked by the employee. And unfortunately, there's no sort of rule of thumb period beyond which local law is going to begin to apply. So unfortunately, it's a bit of a grey area. If in doubt, I would say an overseas work sort of continues beyond anything more than a few weeks. I would say that it's going to be prudent to seek some local employment advice. We often get asked if a local employment contract is needed, and there may be a requirement in the host country to put one in place under local law. You might have also, we're going to have a look at Nomad visas later on, but you might have the terms of a Nomad visa requiring there to be a local employment contract in existence. You can't really know for sure unless you get local employment law advice. And even when you don't use a local employment contract, and the relationship then continues on the basis of the current UK employment contract, you're probably still going to want to know at least what the obligations are in the host country. So if you do want to make things crystal clear at the outset and ensure compliance with local law, the alternative is to put in place a local employment contract, or at least issue a side letter where you're setting out those local law entitlements during the overseas work period. And obviously, the longer, as I said, the longer the overseas work period continues, the more need there will be to set out what rights the employee has. Pensions and tax. I won't say too much. Obviously, Marilyn's going to cover off lots of the tax issues. I've mentioned pensions. Obviously there might be additional pension obligations in addition to the auto-enrollment or contractual pension obligations which employees have under UK law, and you're just going to want to make sure that you're aware of those. Tax. What I would say on this is that even if your employer doesn't have a corporate presence in the country where you are working, there are still countries which, and I think France is one of them, require the overseas employer to register in that country as an overseas employer to pay tax and social security. So even if you're not establishing a corporate presence there, you still may have certain corporate obligations to register in the host country. And the last thing I'll say is in relation to restrictive covenants, you've got to consider how remote working is potentially going to affect the protection afforded by, and then the enforceability of covenants. Your non-compete, your non-solicitation provisions. Are there restrictive covenants in your contract? And if so, are they even permissible? In lots of countries, restrictive covenants are not possible. And if they are, they might be subject to certain parameters, certain limitations. And this is when having local advice and a local employment agreement actually, tailored to what's possible in the host country might be the most advantageous way to proceed to safeguard the employer's interests. And lastly, if an employer is going to have access to confidential information, you've got to identify how that information is going to be protected, and what additional security measures you can put in place. And actually, that's probably a good point at which to segue to San Francisco. Oliver is going to take us through some of the data security issues. Oliver, how's the weather in San Francisco?
Beautiful, Tim.
Over to you.
Great, thanks. So I suppose it sounds obvious, but it's an important issue. When you've got staff working overseas, you're going to be sending them data, either because they'll be downloading it directly, or because you'll be giving them remote access to your systems in much the same way as you might be giving them remote access if they were working in the UK. Now, in either of those situations, you've got a data transfer for the purposes of UK data protection law. And where that's the case, you need to be aware of the restrictions that UK data protection law applies to those international data transfers. Now, the first thing to say is that fortunately, if you're transferring data to your own employees, then that transfer won't be restricted under the UK regime. So, for example, if Tim is working in Mauritius, logging on, doing some emails very diligently, that's not going to be an international data transfer from the perspective of our firm. However, there are situations where having staff outside the UK might result in restricted transfers. So the first situation that one's got to be very alive to is a situation where those staff are not being directly employed by your organization. So if their presence in another jurisdiction is being arranged other than by means of a direct employment relationship, then permitting them to access your systems remotely is likely to qualify as a restricted international data transfer. The other thing to be aware of where the presence of the staff outside the UK might cause restricted data transfers is if their overseas working means you're using other service providers or intermediaries who you might not otherwise have been using in order to facilitate that international working relationship. So a bit later in the talk, we'll have a look at employment intermediaries and some of the issues around those. If you were to use an employment intermediary to help administer the relationship with a member of staff who's working overseas, then information which you send to that intermediary, typically HR information, would be subject to the rules on restricted international data transfers. So if you will be making a restricted transfer, you need to make sure you have an appropriate compliance mechanism in place. Now, some countries are covered by what are known as adequacy regulations under UK data protection law, and that means those countries are treated as having essentially the same level of protection for personal data as the UK does. And if you're transferring data to those countries, you don't need to take any additional steps to safeguard the data. The list of countries which are covered by adequacy regulations is relatively short. We'll be circulating slides later, and the link on the slide there will take you to that list if you want to see whether you're in a situation that's covered by those adequacy regulations. If the country isn't covered by an adequacy regulation, then you're going to need to put in place what are known as appropriate safeguards. Now, the law provides a few different options there, but the most common approach is to carry out a transfer risk assessment and then put in place an international data transfer agreement using the standard form that's been approved by the regulator in the UK. And again, there's a link to the relevant documents on the slide there. So, overall message on the international data transfers piece, you need to take the time in the same way that you're taking the time to think about how the employment relationship is going to be structured. You need to think about how those data transfers are structured and whether there are additional compliance steps that you're going to need to take in order to avoid inadvertently breaching the legislation. If we move on to the next slide, there are a couple of other data protection issues that are also worth giving some thought to in this context. Now, Tim alluded to the idea of kind of falling within scope of employment laws within the jurisdiction where your members of staff are working. And that's also potentially a consideration in terms of the data that they're working with and the data you're using about them. So various different jurisdictions have data protection laws that will apply to data that's being processed in those jurisdictions. Some jurisdictions have data protection laws that attempt to assert a degree of extraterritorial effect. And the key example there is the European Union, the GDPR. Businesses with employees in the EU, and that's kind of whether they're directly employed or not, need to consider whether those employees qualify as what's known as an establishment in the EU. If they do, then any personal data processed in the context of that establishment will be subject to the EU GDPR. Now, whether an employee or group of employees does qualify as an establishment in the EU is pretty fact specific, so you'll need to look at each individual case, but the core element is whether there's a stable arrangement carrying out economic activity in the EU. So to give a very basic example, if you had an employee who decided to work from Spain for a few months whilst visiting family there temporarily, that's unlikely to qualify as an establishment. On the other hand, if you have an employee living in Spain permanently who's there to manage your European sales, then that is likely to qualify as an establishment. And then you need to think about whether EU GDPR is going to apply to what they're doing. Regardless of which jurisdiction's data protection laws apply, obviously maintaining appropriate security measures is going to be paramount. If remote working is a normal practice for your organization, then hopefully you've already got in place secure facilities for remote access to your systems. But there are also some other practical security issues to bear in mind too. For example, you're going to need to consider whether those staff overseas are using their own devices or devices that you've issued. You need to think about whether that distinction affects your ability to control data that's actually on those devices. And if you did have a security breach where it appeared that a device had been compromised, do your IT teams need physical access to the device in order to be able to investigate and remedy that situation? If that happens, do you have a process for retrieving the device? Finally, last thing to think about, if you are relying on employment intermediaries, as well as thinking about the international data transfer obligations, you also need to think about what service contracts you've got in place with those intermediaries and whether those contain the necessary provisions to deal with their role, usually as your data processor. Fairly prescriptive rules under the UK regime, and of course there may be local data protection rules around that as well. So a few things to think about, none of them insurmountable, but important to deal with at the beginning. And with that, I will hand you back to Tim.
That's really interesting. And I am just going to pick up some issues on the immigration side of things, because obviously a key issue in the whole remote working arrangement is whether someone's actually entitled to live and work in the host country. It may be that the employee has a passport or a visa that allows them to enter and work in that country. But I would say it's not just the employee's issue. Employers also need to ensure compliance in this area. I mean, if you contrast it with the example of someone coming to the UK to work and doing work on behalf of their employer from the UK, even if they're not transacting business, I would be counselling the overseas employer to make sure that they have the correct permission in which to do so. And I'll mention the absence of a UK Nomad visa in just a moment. But clearly, employers can't encourage employees to rule break or just to turn a blind eye to immigration permission. The consequences can be quite severe for both the employee and the employer. And clearly you're going to want to undertake that assessment as part of considering the whole sort of remote working request. That's got to be a key element to your consideration of it. What I would just make a reference to is the whole Nomad visa phenomenon. It's a phenomenon that has opened the doors, I guess, to international remote working. I recently read an article that sort of suggested that the popularity of Nomad visas was on the wane, or was slowing, at least, as the reality of working remotely gradually sort of bites. Perhaps those are the same issues that affect remote working employees in the UK too. Things like isolation, lack of team time, and lack of practical support. But for certain categories of worker, the advent of nomad visas can offer actually quite a bit of flexibility. Nomad visas are basically those that are personal to the individual, and they allow them to work overseas for usually a limited period. And they are often subject to the requirement that the individual's not obviously transacting any business in the host country, and your employer doesn't have a corporate presence there. And they're often subject to some quite favourable tax rates. One of the main advantages for the host country is attracting talent, attracting people who may have more financial means to spend in that host country and to potentially pay more tax that the host country otherwise wouldn't have received. So that's why in certain of these nomad locations you get more favourable tax rates to encourage people to relocate there for a certain period of time. And if we move on to the next slide, you can see the kinds of countries, lots of exotic locations that you can move to, and they're gradually increasing the number of nomad visa countries, offering that type of temporary nomad arrangement, gradually increasing. So if you look on the next slide as well, we have a list. Obviously, we'd be sending these out so you can consider at your leisure where you want to go to and work remotely from. But there are an increasing number, and we're just going to look at one of those locations. Oliver mentioned Spain previously, and we're just going to have a very quick spin through the requirements of the Spain, the Spanish nomad visa. It's relatively recent, actually. I think it's earlier on in the year that Spain have introduced this, and it allows you to relocate to Spain for up to a year, and I think that can be extended by a further 3 years. So it's actually quite a long period that you can spend in Spain under this arrangement. And there are certain requirements, obviously, that you have to meet in order to be granted a nomad visa. You've got to have private health insurance. You've got to have worked for your employer outside of Spain for at least 3 months before your application. You've got to complete certain forms relating to Social Security in Spain for those contributions to be made. You've got to give proof of your finances, so you've got to have at least twice the level of the Spanish minimum wage, and you can see those amounts on the screen there. So you've got to show that you've got those means in order to support yourself during the nomad remote working arrangement. And you've also got to have a certain level of qualification. So you've got to either have a university degree or a professional certificate confirming that you've got at least 3 years experience. So as I say, if you can meet all those requirements, you can spend up to a year in Spain, which you can then extend for a further period of up to 3 years if you wanted to do so. And as with many of the other nomad visas, you can also benefit from a much lower rate of income tax than other residents in Spain, subject to certain requirements. I think it's called the Beckham Law, which was first put in place when a certain English footballer, who I'm sure you can't guess who it is, went to play for Real Madrid back in the noughties, and a more favourable tax rate was brought into. Well, I can't imagine it was to assist him, but it was as a result of tax litigation, I understand, at the time. So there could be quite a bit of admin on both sides. You do, employer and employee, you've got to have a look at those Social Security obligations. You've got to file those forms, and you've got to make the visa application, and you've got to keep on top of your obligations whilst you're going through the nomad visa period. There is no, I said I was going to talk about UK nomad visas. I mean, there is no UK nomad visa for those employers who are potentially interested in sending people to the UK. Not yet, and frankly, it's not likely given the current tenor of government communication regarding immigration matters. There are other non-sponsored immigration routes into the UK under the immigration rules, things like youth mobility visas, which require which permit nationals of certain countries to come to the UK. You've got your global talent visa for those who are, very highly talented to come to the UK, and you've also got the high potential individual visa. So various routes which don't require sponsorship and which allow individuals to come to the UK for a certain period of time, but no Nomad visa for the moment. Oliver mentioned I was going to talk about employment in intermediary companies, so slightly a mix of the immigration employment matters. I'm just going to mention employers of record, employment intermediary companies. I mentioned the administrative burden on both employer and employee of organising an international remote working arrangement. Intermediary companies or employers of record are basically intermediary companies that they're established in the host country and basically take care of the entire administrative side of the employment relationship. So rather than a Nomad visa arrangement, the intermediary arrangement is when there's a direct employer in the host country, but they're really an employer only in name. Probably a word of caution in relation to using employers of record overseas. Firstly, many countries don't actually allow it. I've seen instances in which employer of record agencies, employers of record, say they can operate in certain countries and they're actually not permitted to. So that's when taking local advice is actually really key, because it might be that in the target host country, they can't actually help you out. And also, even if they can, it doesn't necessarily insulate the employer back in the UK. Well, it doesn't insulate them at all from the tax or employment law liability. Not only might the local sort of courts find that actually the UK employer is the de facto employer anyway and is liable for tax and employment issues, but contracts with intermediary companies usually set out that any such liability is going to be passed up the chain back to the UK employer. So they can be useful and they can help with the administrative side of employing people overseas, but they need to be used with eyes wide open, basically, and with the potential for receiving local advice to make sure that that kind of arrangement is viable. So I think now is the time when we scoot back over to London, and Marilyn is going to take us through some of the tax aspects of employing people who are working overseas. Marilyn, over to you.
Thanks, Tim. Well, unlike your and Oliver's exotic locations, London is as gloomy as tax on this less than bright and sunny morning. But the thing to understand about the tax issues is that they affect both the employer and the employee, and the employee status can affect the employer. So that brings in issues like, are you going to require the employee to take local tax advice to find out what his status is, what the tax issues are? Are you going to pay for it? Do you at least need to alert the employee to the fact that these issues can arise? So what are they? The starting point is going to be residence, with the honourable exception of the United States and Eritrea. Most countries other than them tax based on the residence of the individual. The US and Eritrea are the only countries in the world which tax on the basis of citizenship. So where your employee is resident will be critical. I'm going to look at some of the income tax issues and also social security implications. What's the impact on NICs of the employee working abroad, and what about the local equivalent? What your employee does abroad could create a tax liability for you. And also, as Tim's already touched on, there can be issues as regards pension rights. I'm not going to say a lot about that, but essentially, can the employee remain a member of the UK pension scheme? If they join a local pension scheme or create the local equivalent of a personal pension, that could have tax implications on them when they return. So starting out with residence, because residence will determine what the employee's tax position is. How long are they going to go for? And where are they going to be resident? Are they going to become resident in the host country? All countries have different rules, and the UK has a statutory residence test, and it's not as simple as you're non-resident if you spend fewer than 90 days here, or it is as simple as you're resident if you spend more than 6 months here. But rules differ between countries, and it is perfectly possible for an employee to become resident in the host country, but to remain resident in the UK. If that is the situation, then potentially they're exposed to tax in both places. So you have to look at the double tax agreement, and the UK has a very wide raft of double tax agreements with many, many countries. And the treaty will work through a number of tests to allocate residence for the purposes of the treaty to one country or the other. Having decided where your employee is resident, the question then is, well, which country can tax them and on what? Or indeed, can both countries tax, in which case the employee is going to need to make a claim for double tax relief, which usually works by way of a credit. So one country will get the primary taxing rights and the other country will have to give a credit against its tax for whatever has been charged. Could we have the next slide, please? So looking specifically at PAYE, if the employee continues to be resident or continues to have a UK tax liability, then the employer is going to need to continue to operate PAYE. If the employee becomes non-resident in the UK, perhaps because they're not coming back here at all or doing work here at all, but they've become resident somewhere else, then in principle, the employee is not liable for UK tax, and there's therefore no reason to deduct PAYE from the earnings. However, it is wise employers will need to go along to HMRC and get them to agree that they don't need to make a deduction. So HMRC will have to agree the residence position of the employee and agree that the employer doesn't need to make deductions. So in practice, the prudent thing to do is to carry on deducting unless and until HMRC agree to change the employee's tax code. Now, if there is, there may be an overlap for a period or it may be a permanent thing. If there's both a UK and a host country liability for income tax on the employee, then they will need to seek double tax relief. And again, you need to look at the treaty to see how that works. The normal position is that the country of residence only taxes employment income. But there is an exception. If your employee is living in, say, Spain, then Spain as the country of residence can tax them. If the employee is also doing work in the UK, then they're taxable in the UK on the UK work. But there is an exception to the exception. So if the employee is working in the UK for less than 183 days and is working for a non-UK employer, then Spain can tax everything and the UK can't tax anything. But in the sort of situation we're looking at, where, as Tim has emphasised, the employee is working for the UK employer only, the exception to the exception won't apply. So the position is country of residence taxes. If the employee is also working in the UK taxes. So the employee is paying tax twice. They will need to make double relief claims, possibly in both countries, because well, possibly in both countries, and they're going to have cash flow issues because they might have to pay both lots of tax up front and then claim it back later. So again, these are things, the complexities that employees need to be aware of before they head off to join Tim on the beach. Next slide, please. Right, one of the reasons which Tim's also touched on why people might want to go and join him on the beach is because those countries, particularly those with digital nomad visas who are trying to encourage talent to go to their countries, give some quite significant tax breaks. There are some, particularly in the more exotic locations, who won't charge any tax at all on somebody going and working temporarily. Other countries, mostly closer to home, have special tax regimes. So in Spain, the rate of tax is 24% up to a salary of €600,000 and 47% over that. In Italy, their system works by reducing the amount of taxable income by at least 70%. And if the individual is working in one of the more sort of remote and underdeveloped regions, the taxable income is reduced by 90%. Greece reduces the income by 50%. And although Portugal doesn't have a digital nomad tax break as such, it has what is known as the habitual non-residence regime, which is available to anyone subject to certain conditions. And under that regime, a Portuguese resident pays no tax on their overseas income and pays only 20% on their Portuguese income. And they have quite nice beaches too, Tim, though no, I'm not sure about palm trees or the cocktails. Next slide, please. Moving on to NICs, it's important to understand that the rules about application and also the definition of where somebody is resident is different for national insurance contributions compared with income tax. Very broadly, if somebody is going, if an employee is going abroad for up to a year, then they can continue to pay UK NICs, and the employer correspondingly would be responsible for the employer's contributions. But if they're going to be overseas for more than a year, then after that 52 weeks, UK NICs cease to be payable. The employee may also be liable for social security contributions in the host country. There are a number of bilateral agreements between the UK and other countries dealing with social security and the consequent benefits. So in some circumstances, for example, or under some agreements, the absence from the UK can be longer. In other cases, it will determine who gets to charge social security payments and what benefits are payable in return. And a further issue for the employee is that if they don't have a full national insurance record, then it will impact on the benefits they can claim, and in particular on the amount of their state pension. In order to maintain their right to a full state pension, they can voluntarily pay class 3 national insurance contributions. So again, this is another thing for the employees to consider, and employers to consider how much information the employee needs to be given. Next slide, Megan. And next slide, please. Thanks. And the employee going and working abroad doesn't only create their own tax issues, they can actually create tax liabilities for the employer. So the employee may be, or they may establish a permanent establishment. And the OECD definition of a permanent establishment is quite extensive, but among the things which can constitute a permanent establishment is a place of management. So if a senior employee goes and joins Oliver in San Francisco, not liking beaches. So he goes and joins Oliver in San Francisco, and they have some deep legal meetings, and management decisions are being taken and strategy formed. That could be a permanent establishment. An office can be a permanent establishment. So if the employee simply has a consistent place where they work from, that of itself can be a permanent establishment. And similarly, if the employee themselves acts on behalf of an enterprise, on behalf of the employer, and concludes contracts on behalf of the employer in the host country, they, the employee, will be a permanent establishment. So it's one thing being or having a permanent establishment that may give rise to compliance requirements, reporting requirements in the host country, but any profits generated by that permanent establishment will be taxable in the host country. So again, there is the potential for double taxation and the potential need to make claims under the double tax treaty to avoid actually paying tax twice. The risks are greater where you have senior employees going, or where an employee is going to be in the host country for a longer stay. And of course, it also depends on the kind of work and what they're actually going to be doing while they're there. But the takeaway point really is that what the employee does can create compliance and administrative burdens and potentially tax burdens for the employer as well. And so, to echo Tim's point that he made at the beginning, the need to think through all these things and develop appropriate policies is really, really important. And on that point, I will take you out of the rain and back to sunny Mauritius.
And that was really such a useful and clear summary of what is quite a complex area. What is clear is that I may be doing the next employment and immigration webinar from Spain rather than Mauritius, because it does seem like a good arrangement. We've just got a few minutes left, and what we could do is have a very quick scoot through a couple of examples of remote working policies that we found, which it might just be useful to have a look at. Now, obviously, these are, well, I've got two examples, and they're both, I guess, the caveat is that they are quite internet-based, agile businesses where I guess there are, a reduced number of sort of physical premises. They're quite new businesses. So the first one, B&B. This looks to be quite a flexible policy, actually. I think it really does entitle people to go anywhere, subject to the employees having arranged work authorization off their own bat. And it allows them up to 90 days a year per location. Now, the up to 90 days is probably in order to avoid any kind of tax liability that might arise. Obviously, more than that, and lots of jurisdictions have tax issues that arise for the individual in that particular location. So they're limited to up to 90 days a year per location. But otherwise, it seems fairly permissible, fairly flexible, to be honest. And the next one is Spotify. And they say work isn't somewhere you go, it's something you do. And it was launched with quite a bit of fanfare. Obviously, Spotify, again, a business that's quite agile, and one in which perhaps it's easier than other sort of lines of work to organize an international remote working policy. But actually, there are quite a few limitations on what Spotify staff can do. Obviously, they have to, again, ensure their own work authorization in the host country. it's got to be within the same region in which they're currently assigned to work. So, you know, that there might be a few limitations there in terms of actually where they can go in the world. And Spotify's got to be a registered entity within the host country. So, you know, that might be another limiting factor. And obviously, it's over to the individual to sort immigration and other permissions. We probably have time for one or two questions, and that kind of leads me on to one of them that's been asked, which is, in our experience, do we see that the employee mostly bears the cost of any additional tax or social security that may occur in these situations? I guess there isn't really a rule of thumb, to be honest. I mean, where you are looking at an individual who is driving the request, then I guess it's typical for the employer to require the individual to bear any increased costs of tax and social security that they become liable to in the host country. But equally, there may be situations actually where this is used as a perk. And if you're looking at trying to retain or recruit someone, the more advantageous you can make that for them may lead you to, you know, consider bearing the cost of any tax and national insurance obligations that become payable in the host country. So it really depends on the situation, and obviously refer to any policy that you have in terms of remote working and who has the obligations. One for Oliver. How compliant generally are companies in the sphere of data security? Generally, are companies aware of their obligations, or is it a case of winging it, or how your experience?
Yeah, it's a pretty big question. I think a lot of the kind of the difference that we see in attitudes to data security and the compliance, particularly in the context of the international work, comes from the degree of familiarity that businesses have with the area. There are some businesses which kind of regard themselves inherently as international businesses. That tends to come with a pretty sophisticated attitude to that compliance work. I think where businesses sometimes trip up is if they've not been used to seeing themselves in that way, and then sort of dip their toes in the water, and sort of from that, without having kind of given it as much thought as they might have done, find themselves inadvertently stumbling into issues. So you know, for example, the point I made earlier about actually physically how do you manage your devices, that's based on situations that we've encountered in the past with organizations that have suffered data breaches and realized that it's really quite difficult to respond when the relevant laptop is literally halfway around the world, and your IT team sat in London sort of scratching their heads wondering how they're going to fix it. So I think it generally depends on the amount of forethought that's been given to the situation.
Time, and actually we've received quite a few questions on the length of remote working. What we're going to do is I'm going to suggest that we wrap those up in the follow-up, which will come out for this webinar. The tide is coming in essentially on the beach on which I'm located, and it's just about time for my evening yoga session. So it only remains for me to thank our panelists, Oliver Willis and Marilyn McKeever, and for you all for attending. We hope you have found it informative, and we very much look forward to seeing you back in the UK, probably for our next Employment and Immigration Breakfast briefing. So have a good day, everyone. Goodbye.